Tonight I'll be talking about creditors, predators, and how to protect your surviving spouse from them. So let's get started. First, we'll cover creditors and predators. So one example of a creditor that could uh, reach a surviving spouse's assets would be a lawsuit. So that would be if your surviving spouse causes a car accident or if they are in debt because they're unable to manage their affairs after you're gone. Creditors would be able to reach any of the surviving spouse's assets in their name after your life. Also, medical care. So we all know the cost of health insurance and health care is increasing at an alarming rate. Also, long-term care. So the cost for health insurance is rising. So too is the cost for nursing home care. And in many cases, if both spouses are alive, even if one is ill or sick, uh, the nursing home can be avoided because the other spouse is there and other family members can step in and provide assistance when necessary. But when there is no surviving spouse available, most children have personal commitments and cannot provide around the clock medical care or support, which leads to long-term care or nursing home costs, which could quickly drain a family's assets. So for example, in Cincinnati, the average cost for a private nursing home room is over $8,000 a month. And in just 1 year, that could deplete over $97,000 in your assets. So this would be unfortunate, especially if the surviving spouse goes into a nursing home for multiple years. It could significantly drain a family's assets. And now let's look at potential predators. And first item on the list is probably the one that you wouldn't expect, family. In some families, there are people who are consistently asking for more and more money from parents or grandparents in the way of sympathy gifts. So perhaps when both spouses are alive, family members stay away because they realize one is always going to say no. But when there's only one spouse living, it's possible that family members would be able to guilt the surviving spouse into giving more and more gifts, even when that surviving spouse cannot necessarily afford to make those gifts. I've seen instances where just one spouse was surviving and family members continuously asked for more and more money, and eventually the surviving spouse didn't have enough left to even pay for their day-to-day costs. There's also competitive affection. This is where family members may approach the parent or grandparents and say, well, I'm here all the time helping you out. Maybe I should get a bigger cut of your assets when you're gone. And it's unfortunate to think about because we don't want to picture our family in this light, but it is a possibility. If there's only one spouse surviving, again, maybe when both were there, they were able to address these concerns. But if there's just one surviving spouse remaining, family members are more likely to do this. Then there are also new friends, we'll call them. One example would be caregivers. Unfortunately, when there's a single elderly person out there, people may target that surviving spouse. And by target, they could just provide care and then, similar to the family members, ask for assets in return. So this is a concern. And then also contractors. There are obviously plenty of great family members out there, friends, and people who have legitimate concerns and care about your parents or grandparents or loved ones. But there are also people out there who don't have those admirable intentions. Same holds true with contractors. I actually have an instance where a landscaping contractor was providing grass cutting and general lawn care services to an elderly individual. The family discovered that this widower was paying over $1,200 a month for very modest landscaping services. And it wasn't something that happened overnight. It was every month the costs would go up and up. And eventually, the family found out that over the course of many months, this widower who really couldn't afford $1,200 a month had been continuously making these payments. So these issues do arise and do happen. There is also the possibility of remarriage. And before I start on this topic, I just want to stress that not all remarriages or second marriages are predatory in nature, but it does happen. While this is probably not the easiest conversation to have with your spouse, it is an important one because when a marriage ends due to death without a higher level of planning, the surviving spouse could remarry and give all of the assets to their new spouse, either directly or indirectly. So let's look at some examples of those. The first is nursing home. Well, you might be thinking, didn't we just talk about nursing homes on the creditor side? And that's true, this isn't a misprint. But what a lot of people don't realize, if you and your spouse are married, you die, your surviving spouse remarries, if that surviving spouse has full control over your assets when they remarry, if their new spouse goes into a nursing home, all of the family's assets are exposed to those nursing home costs and could be lost indirectly simply by the fact that the surviving spouse remarried and unfortunately the new spouse went into a nursing home. There are also accidental changes. So there's no planning in place for a second marriage. If your surviving spouse dies first, it is possible the majority of assets by default go to this new spouse. In effect, the first spouse to die in that scenario loses, rather their family loses. And I'll talk more about this in the next section. There are also intentional changes. So if a new spouse has targeted a particular widow or widower and convinced them marriage is a good idea, and that surviving spouse may be in a compromised state at that point. It is possible, too, that the new spouse will convince your previous spouse to make a change in their estate plan, removing all of the other family members. So what I'll cover today includes estate planning, asset protection, balance between the two. And for those who have seen my presentations in the past, I'm a visual person, so I like to show and explain how different devices work. So let's start with estate planning and see how typical estate planning techniques protect or do not protect against creditors and predators. So first, joint ownership with survivorship. What is that exactly? Well, if you own real estate and you are married, it is very likely your deed is titled joint with the right of survivorship. The same holds true if you have a joint bank account or a vehicle in your name and your spouse's name. What that means is, upon the first spouse's death, the asset automatically transfers to the surviving spouse. And some benefits of that: the transfer is automatic, meaning there's very little legal work that is required. The transfer avoids probate. Some drawbacks, though: there's no control exerted after the first spouse's death, meaning the surviving spouse can do whatever he or she likes with that asset. In turn, that also means there is no protection. So if the surviving spouse is sued, goes into a nursing home, decides to change their estate plan, they can do that and transfer assets to anyone they like. So really, this doesn't provide any creditor or predator protection. A beneficiary designation. This is used if you have life insurance, retirement accounts, and the way it functions is the owner of the asset, upon their death, then transfers an asset to a designated beneficiary. It's very similar to the right of survivorship, except here, here too, it avoids probate. And in this case, you can add contingencies. So if my spouse is deceased, the asset goes to my children, as an example. The cons with this item, again, there is no control, meaning once you are deceased, you have no control over what the beneficiary does with that asset. And in addition, you have no protection for the surviving spouse of that asset once it is transferred. Next, we have a will, something I'm sure everyone has heard of. But does it provide any creditor protection? Well, let's see how it works. After your life, if you use a will to transfer assets, those assets go into probate court, and in this hypothetical, the sole beneficiary is the spouse. Well, the benefit here is you get to add some contingencies. So if spouse is deceased, it goes to another person. You can name guardians if you have minor children, and that's really it. The cons, if the assets go through probate, they are subject to your creditors. So if you are married, you have personal debt, be it credit cards, medical debt, the assets passing through probate are subject to your creditor claims. Also, here again, the distribution is outright. So in our hypothetical, it's outright to a surviving spouse, which means there is no creditor protection and there is no predator protection. So another device, a joint revocable trust. Now this device is very common for estate planning and is it's necessary because it allows you to structure a plan that avoids probate and goes to a surviving spouse or children. So the pros here, this device avoids probate, you can add contingencies, and really contingencies to a much greater extent than you can in a will. With a trust, a joint revocable trust, you can make certain statements. For example, if my assets are distributed to children and the children are under 18 or 25 or 30, those funds must be used for health, education, support, maintenance, the essentials in life, and not until a later age will the assets become available. So that's beneficial because if both spouses are deceased at the same time, the assets avoid probate, and the distribution will be in a way that provides for more responsible spending. The drawbacks, though, come if only one spouse is deceased. Here again, the assets would go outright to a spouse, which means there's no asset protection for the surviving spouse. So too, can it be available because the joint plan is subject to potential change by the surviving spouse.
Excuse me, Elliott, may I ask you a question?
Sure.
As I listen, should I be concerned if my attorney only suggested I use one of the options?
One of the options we just spoke about?
Yes, yes.
Well, not necessarily. And just to reiterate, if anyone has questions about their particular planning, they can, of course, speak with their legal counsel. But these devices, especially the joint trust, are often used for essential estate planning. What we're going over today are additional considerations beyond the essential planning techniques. In fact, in my experience, most couples, when asked, will say they are comfortable with the surviving spouse having full control. I've found, though, that clients who come back for revisions or updates when they no longer have children that are minors or in college, they're approaching retirement or in retirement, or have simply experienced directly or indirectly a creditor or predator, are more concerned about asset protection The joint revocable trust is very common, but what I'll go over next is really more advanced planning and more advanced asset protection planning. So just to summarize, joint ownership with survivorship, beneficiary designation, the will, and the joint revocable trust, they don't really provide creditor protection for the surviving spouse. All of these are important devices and have their place in estate planning. There is one way that you could use these devices in a manner that could provide asset protection for a surviving spouse, and that would be an outright distribution upon death to both a surviving spouse and to your children or other beneficiaries. In that case, since you're giving the children something, let's say a life insurance policy, that policy automatically could go to children. It could even go through the trust to the children. And then the surviving spouse retains all other assets. So the benefit of that is you have certainty that the children receive something. The drawback, though, is what if the surviving spouse needed those assets, or at least needed the income stream from those assets? So it's not a perfect option, and I'll cover some options that provide a little bit more flexibility. So we discussed creditors and predators, estate planning techniques, the simple estate planning techniques. Now let's cover asset protection planning. So the first device in asset protection planning is an agreement to create a mutual estate plan. So the way this works is those spouses sign off on a joint revocable trust, let's say. Upon the first spouse's death, that trust cannot be changed. So there is a lockup at the first spouse's death, and the surviving spouse cannot change the rules after one spouse is gone. Then upon the second spouse's death, the assets distributed, avoiding probate, and go to the beneficiaries both parties agreed on. So the benefit here is that the surviving spouse still has full use of the assets. So they could go on a trip around the world, they could improve their house, they could buy a car, anything they want, as long as they don't change where the assets go upon their death. The benefit here is that they cannot change where the assets go upon their death, so that would address some of the creditor concerns, meaning people forcing or coercing the estate plan to be changed, adding them as either a party or adding them as a greater beneficiary. There are no limits, you can place limits on gifts and loans in this type of agreement. For example, you could state that if one spouse is gone, the survivor agrees never to give any gifts over $1,000 a year, for example. And if any gift is given, that it must be given equally to all parties, or if there's a loan, all parties have to agree. So those are the benefits. Here are the drawbacks, though. There's still no creditor protection because the assets are still owned by the surviving spouse. The creditors can get to those assets. And another con is that the spouse has full use of the assets. You're probably thinking, well, isn't that listed above as a pro? Well, it's just as equally relevant as a con, because if that surviving spouse spends the assets in a way that is unwise, or purchases things or pays for things that are contrary to reasonable standards, there's no protection, and that spouse can spend things on anything they like. That includes if they remarry and spend assets on the new spouse, because if they're not giving gifts or if they're not giving away assets after their life, they're not violating the plan. Also, let's say this agreement is in place, your dad dies, your mom survives, and your mom is acting contrary to the agreement, you would have to sue your mom. And that's never a good thing to have to do, to enforce the agreement if a surviving spouse decided on their own to act contrary to the terms. So another option is to create separate trusts. So there would be one trust, and upon the first spouse's death, a second shelter trust would be created, and that shelter trust would include assets specifically designated to fund the shelter trust. That could be a percentage of the overall assets. It could be a specific asset or specific assets, for example, life insurance or tangible personal property that are family heirlooms. Those assets could be directed to the shelter trust, reserving the remainder for the surviving spouse. So the benefits here, you have creditor protection on the assets that are directed to the shelter trust. This shelter trust could also provide some income and some principal to the surviving spouse if necessary. So for example, if the surviving spouse has plenty of money to pay for their health care, their other costs, they get remarried, they pass away, anything still left in the shelter trust would pass on to the next generation. And if the surviving spouse never needed any distributions, all of the assets would be protected. Then you have certainty on distribution, because ahead of time you would have agreed between the two spouses what goes into the shelter trust, and no matter what happens during the life of the surviving spouse, you have certainty that whatever went into that shelter trust is going to your children after your life, or your beneficiaries, whomever you designated. Some drawbacks, you have to make a decision before death on what goes into this shelter trust. As I said, it could be a percentage of assets, it could be specific assets, but if you create this plan, fast forward 20 years and maybe you don't have the same amount of assets as you did before, or you don't have the specific assets listed, there's some risk that your plan wouldn't be realized. So this one would require a lot more additional maintenance, ongoing maintenance, to ensure that your assets reflect the plan that you have in place. Also, you have a Medicaid look back. Anytime you make a transfer of assets, Medicaid can look back for 5 years if you apply for Medicaid to determine if a transfer was made during that 5-year period, and it can create a penalty for any transfers during that 5-year period. Unfortunately, Medicaid also deems death to be a transfer. So if upon death, assets go to the shelter trust, remaining assets are in the marital trusts, if that surviving spouse has to go into a nursing home, there is a risk of a penalty period being created. And then the marital trust is still exposed. So if you direct assets to the shelter, whatever remains in the marital trust is still accessible by the surviving spouse's creditors. So a very similar option to the separate trusts, but with a minor adjustment. So same picture as you saw before, but this time we allow the surviving spouse to decide what assets go in the shelter trust after your death, assuming you're the first to die. So what this does is it ensures the spouse can analyze the assets at the time of your death, can decide how much do I need in my name, how much does a shelter trust provide, and based on the facts at that time, determine what can be allocated to the shelter trust. Typically, this is called a disclaimer, and it's made within 9 months after the spouse's death. And then the balance of those assets end up in the marital trust, which we talked about before, and the pros and cons are very similar. You get the creditor protection with the shelter trust. You get to provide for the surviving spouse if necessary. You have more flexibility on the division of assets because if the surviving spouse gets to decide what goes into the shelter trust, they have a lot more flexibility at the time to determine their needs going forward. The drawbacks, though, the decision of death. You are hoping that the surviving spouse will make the right decision. he or she may allocate too much, they may not allocate enough. Um, that is a risk involved, and that is one of the drawbacks. Similar to the separate trusts before, there's still the Medicaid look-back issue because a disclaimer is also deemed a transfer, and the marital trust is still exposed. So the final option we'll look at is an irrevocable trust. So the way this works is during life, you have assets, and you can direct a certain amount of assets or certain assets to an irrevocable trust. With this option, assets would be moved into the irrevocable trust while both spouses are alive. Depending on the structure of this trust, it could continue to provide income or use of the assets. So income, if you have stock, let's say, the dividends produced off of that, or use of assets. If you have real estate, you could put the real estate into this type of trust and continue to live there. But by giving up ownership of the assets, you do receive some asset protection during life or during the life of both spouses. So that's probably the best benefit here is you get 2x of creditor protection for both spouses. None of the options provide this, but also none of the options require giving up some control of assets during the life of both spouses. As I mentioned, you can retain income from this trust, or if you have real estate, you could continue to live in the real estate. It also creates a potential stop loss of assets. So if both spouses decide, let's put a certain amount of stock or a certain amount of real estate into this irrevocable trust, as long as you don't go into a nursing home for 60 months after the transfer and require Medicaid, and as long as you are not making that transfer to avoid a creditor that you know of at the time, those assets are always going to be protected. The drawbacks here, it cannot be changed. It is an irrevocable trust. So the terms are in place, and those terms really can't be changed. Now, there are some ways to adjust provisions in the irrevocable trust and some powers you can retain depending on what your asset level is. But generally speaking, you should go in anticipating that, by and large, the terms cannot be changed. There is a timing risk. As I mentioned before with the Medicaid look-back, if you put assets into the irrevocable trust, you want to be certain that there's not a high likelihood of you going into a nursing home and requiring Medicaid within 60 months of that transfer. And up front, there is more administrative work because, as I mentioned, you're probably not going to be the trustee of this irrevocable trust. It may require a family member or a third party acting as trustee, whereas with the revocable trusts, the ones that I discussed before, those all allow you to remain as the trustee. Something worth noting, even if you have an irrevocable trust, you can also have a revocable trust, which means all of the prior planning options I just covered are still available. So you can build or put these options together and build upon them to have different levels of creditor protection. So in summary, an agreement to create a mutual estate plan, separate trusts with an automatic distribution, separate trusts with a disclaimer where the surviving spouse controls, and an irrevocable trust. These are all devices that can be used. This is not an exhaustive list, but a general overview of the things that are important to consider when contemplating asset protection planning and protecting against creditors and predators. But next, let's look at a balance between the two, estate planning and asset protection. So first, we talked about estate planning, which generally covers probate avoidance. It also covers things that we didn't necessarily talk about, creating powers of attorney, living wills, things that address the distribution of assets after your life and ensure protection during your life. And then asset protection planning does overlap with estate planning, of course, but it primarily relates to protecting assets from creditors and predators. And when doing this type of planning, it's important to have balance. You have your assets, you have your surviving spouse. You want to protect your assets, but you also need to support your surviving spouse. You don't want to be too heavy on one side or the other. Um, and really, that's the importance of working with a professional through these issues. The intent of this webinar was really to educate on potential issues. If you have specific questions related to your specific needs, it's best to have a one-on-one review with your legal counsel to make sure your specific family goals and objectives are addressed.